take us through what your strategy would be if you were what decision would you be appealing? What part of the decision relative to the suspension of Watson would you think they have a chance of getting that suspension reduced back to 6 games or something less than a year?
Well, I would choose 2 lines of attack. Again, we have to wait for this written decision from arbitrator Peter Harvey. He may have other aspects of the decision that can be challenged in federal court. But as I anticipate this playing out, I see 2 potential lines of attack. Number 1 is the issue of fair notice. And this was an issue that Judge Robinson outlined in her August 1st ruling, that the NFL is trying to discipline players for nonviolent conduct the same way that they're disciplining players for quote unquote violent conduct. And this became an issue when Ray Rice first got suspended. The league was hamstrung by the law of the shop, and that prior arbitral precedent limited the league to 2-game suspensions for violations of the personal conduct policy. So the league had to amend the policy, and they gave fair notice to the players of the severity of the discipline if they engaged in the prohibited conduct. Sue Robinson is arguing that the league now needs to give the fair notice to the players that nonviolent conduct can be disciplined as severely or more severely than violent conduct. And based upon prior arbitral precedent, the longest she can go on a discipline for 3 games, or a discipline for nonviolent conduct, is 3 games. And she enhanced it by virtue of the fact that there were multiple offenses. But her main point is that the league could not get a 1-year suspension because that would be the type of discipline that would be commensurate with the severity of discipline for violent conduct, such as domestic violence, the use of physical force. And in order for the league to penalize players and discipline players as severely for nonviolent conduct as they've done for violent conduct, the league has to give fair notice, such as an amendment to the personal conduct policy. So this fair notice argument is akin to an industrial due process argument. It really requires the league to give notice to the players, not only that their conduct could subject them to discipline, but has to also give notice as to the severity of the discipline associated with that conduct. So that's argument number 1, and that's the linchpin to her ruling as to why she stopped at 6 games. It was a fair notice issue, the fairness and consistency of the discipline, and whether the players receive fair notice from the NFL that they could be subjected to that range of punishment for a non-violent personal conduct policy offense. Issue number 2 would be arbitrator bias or evident partiality. I know the players have already agreed in their collective bargaining agreement to have Roger Goodell, the NFL commissioner, decide appeals under Article 46. But this goes one step further than just Roger Goodell. He has transferred the authority and outsourced the decision-making to a lawyer, an outside counsel who works for the National Football League on pending cases. He's a member of the NFL's diversity committee, and he's also a leader for an organization called Futures Without Violence, which advocates on behalf of victims of domestic violence and sexual assault and sexual violence. And I think having a decision maker, a judge who's such an advocate in his professional life for victims of sexual violence, I think may cast a pall over his objectivity on an issue. And I realize Roger Goodell, if he had been making the decision, would have a built-in bias by virtue of the fact that he wants a 1-year suspension. But the lawyer, I think, takes it one step beyond Goodell and has not only a league insider and a lawyer who benefits from his relationship with the league, but he's an advocate for victims of sexual assault. And I think that takes his role as an arbitrator and puts it into the category of being a biased or evidently partial arbitrator, which could be grounds for vacating the arbitration decision. I know the Players Association tried that argument in Deflategate and lost it, and they tried it in Adrian Peterson and lost on that issue because the appeals courts in both of those lawsuits concluded that because the players had agreed to have Roger Goodell be the ultimate fact finder and disciplinarian, that the players ceded that authority to Roger Goodell and they got exactly what they bargained for. But I don't think what they bargained for here was a lawyer who works for the league, that does a lot of work in the domestic violence area as an advocate. I think this could be an open question, and the Deflategate and Peterson rulings took place in different federal circuit courts of appeal, the Second Circuit in Deflategate, the Eighth Circuit in the Adrian Peterson case. Delaware is part of the Third Circuit U.S. Court of Appeals, which does not have to mandatorily follow the decision-making in either the Second Circuit or the Eighth Circuit. The Third Circuit, as well as the lower Delaware federal court judge, can make an independent ruling as to whether the arbitrator has the type of bias that would require the vacating of his decision on the basis of evident partiality. So I think that issue is still potentially in play, and I expect the Players Association to raise it along with the fair notice issue, as well as any other issues that come up in an opinion that we haven't even seen yet. But I can identify at least two grounds that the Players Association can raise if this discipline is enhanced to a full season or anything over 12 games.